please let me say a couple of words. It is a hallmark of her life as a professional that she embodies what the Commission on Professionalism was established to promote: professionalism. She comes at the issue of what will be the future of the legal profession, of court services, very steeped in all aspects of being a lawyer. She started for 10 years or so, was an assistant public defender for Cook County. And then she's been in every level of the judiciary in Illinois, at the circuit court level, appellate level, and now for almost 10 years on the Supreme Court. She brings leadership, thoughtfulness, and deliberation to what does it mean to be a profession, to innovate, to keep in step with the times, but make sure we hold on to the value of our profession. So I'm thrilled that she is here to address you today, and please help me welcome to the stage Justice Mary Jane Theis.
Thanks, Jane. Thank you so much.
Thank you.
Well, thank you, Jane. And on behalf of my colleagues on the Supreme Court, most especially Chief Justice Lloyd Carmeier, and maybe even more especially the real godfather of the Commission on Professionalism, Justice Bob Thomas, who's with us, the court is thrilled to once again have the Commission on Professionalism host this conference. The work you're going to do today, both hearing about new ideas, considering them, weighing them, it's really important for our profession and for our court system. Let me start by talking a little bit about the landscape of where we are now so we can kind of figure out where we should go. And this is the kind of work that in Illinois, our judicial conference is in fact conducting right now. Our Constitution requires that our judicial conference consider the court system and make recommendations. So we're in the middle of this study of our court system. So I have a bunch of statistics I'm going to share with you, and hopefully they'll help you see where we are today. One thing we learn about statistics is we have some data and maybe not the right data, and we need to work on that so that we can understand the court system better, understand our profession better. But here are some ideas. The National Conference of State Court, Supreme Court Chief Justices did a study about 2 years ago of civil courts across the country, and they call it the landscape. So let's start there. What do our civil courts look like across the country? What they found were some really interesting statistics. When you picture what's happening in our courthouses about civil cases, they found about 64% of all the cases were what they call contract cases, debt collection, mortgage foreclosure, landlord-tenant, 64% of the cases. Another 16% of the cases were small claims cases, under $12,000. About 9% of the cases were family cases, some kind of family disputes. Only 7% of the cases across the country in civil courts were tort cases. Picture how much energy we put into tort cases. They're really a very small part of the larger picture of our court system. Then there's about 4% of other. Picture all the other issues in our civil system that are about 4% of our court system. So that gives you some sense of who we are, at least in terms of what the numbers are. We know another incredibly important statistic and understanding of where we are as a court system and as a legal profession is the dramatic rise of self-represented litigants. Here in Illinois, the Access to Justice Commission studied our cases here in the civil world in Illinois, and what they found was that in over half of our circuits, in about 70% of the civil cases, at least one party was self-represented. That's dramatic, and this is a different kind of legal system than we've had in the past, when huge numbers of people come to our courts self-represented. In some of those cases, what we find is what we call asymmetrical representation. So you have a lawyer, debt collection lawyer, expertise on one side, and a self-represented litigant on the other side. In many cases, both sides are self-represented. We find that especially in family courts. Now, if you talk to a judge, you'll quickly hear that this is the number one issue for judges. It is incredibly difficult for judges to balance all of the interests for people who don't understand our system. They literally don't speak our language. And the biggest issue is the ethical issues for judges. What is their role when one side is very familiar with the law and the other side is not at all? What role should the judge play? This may be the most important issue, as I say, among judges. Let's talk about criminal a little bit. On the criminal side, we picture criminal courts being adversarial courts. The biggest trend in criminal cases right now is problem-solving courts. Let me explain what that generally means. Historically, someone pleads guilty to drug possession. They're placed on probation soon. They come in with a garage burglary case. Usually, we'd find them in violation of probation and send them to the penitentiary. Today, all over the country, the focus has been changing that adversarial system and looking at what is the underlying cause of this kind of case. What's happening in this person's life? And so the court becomes non-adversarial and becomes a therapeutic court. In other words, the judge becomes the team leader with highly professional probation officers and treatment providers. And the outcomes have been terrific. The numbers have shown this is very powerful. But let's think about it for a minute. These judges are trained to be lawyers and judges, and they're used to ruling on adversarial motions. They're not trained as therapists. Or look at the other important pieces here. The probation officers are doing work that was way beyond what we ever considered probation to be. Today, they're talking about cognitive behavioral modification. And of course, we have to have deeply sourced treatment providers. This is real expensive. Very, very expensive in our court system. And in a court world where our budgets are getting cut all the time, we've lost about 10% of probation officers in Illinois. At the same time, we're asking them to do more. Another interesting piece in criminal law is restorative justice courts. I'm not going to spend a lot of time on this. These are new ideas, but my point is criminal courts, like civil courts, are changing dramatically. In many ways, the future seems to be some kind of non-adversarial system. The biggest change that I want to talk about, the biggest statistic that I think we have to think deeply about, is that we have found that there is a drop of about 40% in case filings, on both criminal and civil. Why is that? We need to think about why is that. And I think we need to think about that today we have competition. We are not the only dispute resolution system out there. People are choosing elsewhere. They're walking away from the court. Why is that? We need to think about that, I think, deeply. Often they talk about cost and inefficiency of time. People are willing to give up their rights to discovery. They're willing to give up precedent. They're willing to give up the right to appeal. Those things that are so important to us, people are willing to walk away from the courts, abandon those ideas because the alternatives are more efficient. So what are we going to do about that? I hope as you look at and hear today about innovations, changes, you think about this important question. What is it that we do as a profession, as a court system, that is different? Are we just a publicly funded dispute resolution center? Or is there something else that we bring, and in a business language I'd say, what is the added value that we bring to dispute resolution? And what I would suggest is that if we think about it deeply, and I think it needs a lot more thought, we are committed, we embrace values, justice values, integrity, enforcement of rights, impartiality, accountability, transparency, all those things that make us different. We have to embrace those, and as we move forward, as we think about innovations, as we think about online dispute resolution, or we think about risk assessment tools, we need to, in my view, step back and say, as we look to the future, although the future is now, as we look to the future, what can we adapt, but what must we hold on to? What are the values that makes us a profession and makes our court system so central to the communities that we serve? Now, that's a big challenge. I don't have all the answers, And I predict after today, you won't have all the answers. But as you consider these stimulating talks that you're going to hear from people, I ask you to continue to think about this. What is it that makes us different? When we make changes, what should we hold on to? What are justice values? So thank you to the Commission for putting this together. Thank you, all of you, for coming today for this hard work. I didn't say it was going to be easy, but it's an important discussion to be had. And I know from this conference will come wonderful ideas that we will continue to discuss and embrace and make changes for the people that we serve. So thank you very much.